This is one of those courtroom moments where the question isn't just what did the defendant do, but what does the system do when addiction, crime, and second chances collide. Today's case centers on Richard Gonzalez, a man with a long history of drug possession, firearms offenses, and repeated encounters with law enforcement. But it also centers on something else: recovery, treatment, and whether the court believes that change is real, or just another chapter in a familiar cycle. We're walking into a sentencing phase, where the defense is arguing that treatment, finally, worked at inpatient rehab at Lifetime Recovery gave Richard tools he never had before. The prosecution, on the other hand, is saying, enough is enough. Prior chances didn't work, the offenses escalated, and public safety is on the line. What makes this case gripping is that it's not black and white. You'll hear admissions of meth, use possession of firearms as a felon, family, tragedy, and genuine emotion. And then you'll hear a judge do something rare, offer a choice: prison, or an incredibly demanding form of freedom. Pay close attention, because everything that follows hinges on whether accountability and rehabilitation can actually coexist.
Okay. All right. Defense, any witnesses, or is just argument?
Just argument, Your Honor.
All right. You may proceed.
Yes, ma'am. As I look at his history, he's got an issue, and all of it seems to circle around drugs. The court did the thing I think that's helping him the most, regardless of the sentence today, and that was he needed treatment. And he got treatment, and he went to Lifetime. I think it was 45 days there. And, Your Honor, since that time, my understanding, the reason he was put back in jail was because he was having some issues with his bail bondsman. And the conclusion, and the only conclusion I can reach about him, it's an excellent one, and that is the fact that treatment so far took on him. And we would submit to the court based on that this court consider probation and all the things that this court can use to make sure he performs well, or in the alternative, this is a cap, sentence him at the lower end of the cap. And once again, this is because, from what I can tell, Lifetime took. And I know he's got a lot more work to keep it working. He's going to have a day-in-day life where you fight drugs, and there's a program out for them. He needs to make a meeting every day for the next 90 days, regardless if he's in jail or not.
This is a classic defense strategy in sentencing, and an important one to understand. The defense isn't denying the past. In fact, they're leaning into it. They're framing Richard's criminal history as a symptom of addiction rather than malice, pointing to treatment as the first real interruption of that cycle. 45 days of inpatient rehab isn't insignificant, especially when the defense argues it finally took. But here's the tension. Courts hear this argument all the time. Judges have to decide whether treatment success is sustainable or situational. The defense emphasizes daily meetings, structure, accountability, essentially asking the court to swap incarceration for supervision. Probation, deferred adjudication, or capped sentencing are all tools judges can use. But there are also risks. So the underlying question here becomes, is the court willing to bet on recovery when prior opportunities failed? Or does public safety outweigh optimism? As a viewer, ask yourself, if you were the judge, would evidence of short-term treatment success be enough to justify another chance?
And then the second enhancement was for a 2020 felon in possession. And so I think there are programs to address drug issues, but there's no program to address somebody that just is committed to possessing firearms for that reason you're applicant.
All right. Thank you. Is there anything you wish to say?
Yes, ma'am.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand. State your name for the record.
Johnny Richard Gonzalez.
All right. What would you like to say?
I'd like to say that Lifetime Recovery helped me a lot because I didn't know how to deal with none of my past issues. I was self-medicating, and with Lifetime Recovery, I learned how to cope. I learned how to ground myself and process the situations, and now I know how to cope with it. And I would like to continue my life with the tools that I learned at Lifetime.
The prosecution's argument shifts the focus sharply and intentionally from addiction to danger. Drug possession alone is one thing, but when firearms enter the picture, the legal calculus changes fast. The state isn't just talking about relapse risk. They're talking about community safety. A felon in possession of a firearm is a bright red line in criminal law, and prosecutors know that judges take that seriously. Notice how the state outlines prior convictions with precision dates, enhancements, drug-free zones. That's on accidental, They're building a narrative of escalation, not recovery. And when they say, there's no program to address possessing firearms, that's a subtle but powerful argument. Treatment may help addiction, but it doesn't undo the danger created by repeated illegal conduct. This is where sentencing hearings become less about sympathy and more about risk management. Even if Richard is sincere, the court has to ask what happens if he relapses again. And what are the consequences if weapons are
What was going on in your life that you were asleep at the wheel of a motor vehicle?
I was going on with family issues, and so I was self-medicating, and I was working as well. So I just didn't know how to cope with none of that stuff.
And when you say self-medicating, what were you using to do that?
I was using methamphetamines so I could still be able to work.
And then in the 2024 case, in that case, you were also in possession of a floodlight. Is that correct? The motor vehicle?
Yes.
Okay. And when did you complete lifetime recovery? Was that a part of your bond?
It was part of pre-trial. Yes. And I don't remember the date I completed.
And was that inpatient or outpatient?
It was inpatient.
Okay. And do you recall how many days that was?
It was 45 days.
Okay. And then just regarding your history, you do have a prior history of drugs and also possessing a firearm, correct?
Yes, ma'am.
And
Just one question. You understand for the rest of your life, especially for the first 2.5 years, you need to make a meeting every day, sometimes more than one day.
Yes, sir.
That's the only way you know you can make it.
Sir.
Thank you. Pass it, Sean.
This is the emotional core of the hearing. Richard isn't minimizing his actions, he's explaining them. Addiction, grief, homelessness, family conflict, and the death of a parent all come into play here. From a legal standpoint, this testimony doesn't erase guilt, but it absolutely influences sentencing. Judges listen closely in moments like this to assess credibility, accountability, and insight. What stands out is that Richard isn't blaming others outright. He admits self with meth, acknowledges prior offenses, and talks about learning, coping mechanisms, grounding, structure, faith, routine that matters. Courts want to hear not just regret, but understanding. And then there are the children. When a defendant mentions minor children, judges weigh that heavily, not as an excuse, but as motivation. Still, emotion alone isn't enough. The court now has to decide whether these insights translate into long-term behavioral change or if they're being voiced only under
None of that
pressure.
stuff before. I didn't know how to ground myself and process it and use my brain. So, but I learned a lot when I was in Lifetime.
What did you learn at Lifetime?
I learned how to slow down and process the situation. And instead of taking off to the races, no, I ground myself and find coping skills as working out or the Bible and working, just staying busy and doing meetings and just speaking about my problems.
Do you have any children?
Yes, ma'am.
What are their ages?
I have a 15-year-old, a 14-year-old, a 9-year-old, and a 5-year-old.
And have you been in their life at all
Yes, ma'am.
while you've been using?
Unfortunately, it's
All right. Any other questions?
No question, John.
All right. So here's the thing. I'm going to give you a choice. Some people I can give choices. Some people I can't give choices. Some people will come before me and they'll say, hey, you just gave this guy a choice. Why can't I have a choice? And I'm like, because you're charged with murder, you know. So I'm going to give you a choice. Here is your choice. One, are you deserving a deferred adjudication? Absolutely not. But I will give you deferred
This is when
adjudication.
the case takes a dramatic turn. Judges don't often frame sentencing as a choice, but when they do, it's intentional. Deferred adjudication is not leniency. It's conditional trust. If Richard succeeds, he avoids a final conviction. If he fails, he faces the full punishment range up to 10 years. That sword is always hanging overhead. The judge is clear. Inpatient treatment or felony drug court. No excuses, no delays. This is structured accountability at its strictest. Daily meetings, supervision, random testing, employment requirements. This is freedom with strings attached, and those strings are tight. From a legal perspective, this is the court saying, I believe rehabilitation is possible, but I will not tolerate failure. It's also a warning. This opportunity is rare, and the margin for error is slim. Would you take this deal? Or would the certainty of prison feel easier than the constant pressure to perform
Going for
perfectly?
inpatient treatment because that's where you would be going. Or this is your other option. I will find you guilty and I will sentence you to 5 years in the prison. Which do you prefer?
Inpatient.
All right. Then this is what the court will do. Counts 1 and count 2 will run concurrently. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. And State, I know you were opposed, but does anyone want to give their opinions on the length of deferred adjudication?
I'll defer to the court.
I would defer to the court too. I think you're using your wisdom to decide where you're going. And I agree. But this guy needs to be in a place, from my life's perspective, that he has to live with this every day. In the words, he's got to constantly see us go to a meeting, go to a meeting, go to a meeting. If you feel anything in your brain, any new thing or old thing, drag your butt to a meeting. That is the one thing you can always simply do.
All right. So there is to be 8 years deferred adjudication, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's
This
to be
case
no
ultimately reflects one of the hardest decisions courts face: punishment versus possibility. Richard Gonzalez avoided immediate prison time, but what he received instead may be even harder: 8 years of deferred adjudication, strict supervision, treatment mandates, and zero tolerance for failure. One misstep could land him behind bars for a decade. The judge made it clear. Recovery isn't just about staying clean. It's about rebuilding trust, protecting children, avoiding risk, and choosing responsibility every single day. This wasn't forgiveness. It was conditional grace. Whether Richard succeeds will depend on what he does when no one is watching. Cases like this force us to ask uncomfortable questions about justice, addiction, and accountability. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.